I thought I'd summarize a little bit of what you've heard so far. There's a number of speakers, and it might be useful for a bit of a recap. First, we had Jay tell you that nobody's going to try and sell you anything. Then we had Erez come and try and sell you a copy of the CICA handbook, which
I don't get a commission from that, though.
And then everybody else on the panel is named Andrew, so that's the rest of that. So the two elements that Jay mentioned of my presentation, I kind of would describe them as a gloom and doom portion, and then a ray of sunshine portion. So let's maybe first start with the doom and gloom stuff, which is the failure to file. So it's very common for companies in financial difficulty to run into problems with money. They can't prepare their annual financial statements typically, and so they don't file them. So we see that all the time, and often that's the first sign to us as regulator that the company is running out of money, other than the fact that we've been monitoring the financial statements all along and we know they're running out of money. So, and of course the reason for that, if filing the interim financial statements, typically they're management prepared. No matter what the money situation is, they can probably get them done. But with the annuals, obviously it's that enormous audit cost that can be prohibitive because guys like Erez are out there charging their fees. So we see that, and we know what happens, and obviously we watch for it, and we do what we need to do. So when a company hasn't filed its financial statements, and typically it's the audited financial statements, first thing that happens is the company appears on our list of issuers in default. So that's a list. It's updated more or less real time. It's on our website. We just put it up there. We know that information services take that information, summarize it, distribute it, circulate it. A question? You're just waving. Oh, okay, no problem. And so that information is widely available. You don't necessarily, you don't want to be on the defaulting issuers list. It affects the reputation of the individuals associated with the company, and of course affects the company itself. Once you're on the defaulting issuers list and you haven't filed, the next thing that will happen is we will issue a cease trade order. And so I won't give you a rule of thumb about how long that takes, but an average might be about a week, so it's actually pretty quick. That isn't to say we won't issue a cease trade order the next day if we have some reason to, and it doesn't mean that it might take 2 weeks for us to get around to it. It sort of depends on a number of factors: staffing, how many other companies went into default at the same time, other factors like that. So certainly don't hold me to the 7-day and call me when we cease trade you on the 5th day. But at least that gives you a sense of, really, once you're on the defaulting issuers list, you're going to be cease traded pretty darn quickly. Just a word about our cease trade orders. In British Columbia, we issue them under Section 164 of the Securities Act. That's something that's done at the staff level. It's done with staff decision making. So there's no hearing process involved. It doesn't need to be confirmed. And once we issue it, it is an indefinite order. So some jurisdictions have a multi-step process where there's a temporary order, maybe 15 days. Then there's a bit of a hearing process, and it's confirmed with a subsequent, more permanent order. But in British Columbia, it's pretty rapid and it's pretty efficient. As part of my preparation for this, I was asked the question, do we ever take enforcement action against individual directors and officers for the failure to file by the company? And the answer is, in terms of a typical failure to file, company ran out of money, just can't file. Generally, it's no, not that I can recall. I don't recall ever a situation where it was very routine, it was just a non-filing. So that's not encouragement to say, okay, I don't have to file anything, I'm safe. But just if the company runs out of money, nobody's coming after you and trying to do bad things. So that's not what we do. That doesn't mean there is an impact to you as an individual, as a director or an officer. So there is a disclosure requirement that happens once a company has been cease traded for more than 30 days. So no matter what company it related to, anytime you're filing a long form prospectus, an AIF, or if you're named in an information circular as a proposed director, if you're a director or an officer of a company that was cease traded for more than 30 days, you'll have to disclose that in that document, and that will follow you around for 10 years. So you don't want to be in default, you don't want to be cease traded, but you definitely don't want to be cease traded for more than 30 days. There's a common misconception that once a company has been cease traded, they don't really need to continue complying with continuous disclosure requirements. So kind of stepping back realistically, if a company is unable to file its annual financial statements, it does not surprise us that the company can't continue filing, its subsequent interims in its next annual. We're certainly not going to issue a cease trade order for failure to file annual, and then issue another one, every 9 months or 3 months. We're not issuing cease trade orders, but that doesn't mean that you're not actually required to continue meeting continuous disclosure obligations. And so the one thing that I would point out or point to is, if you are in this situation, a company has been cease traded. Be very mindful, particularly if the company still has some sort of operations going on. If there is a material change that happens, that is the one thing in particular that you want to make sure you do file, because if the company is able to bring itself back into good standing, maybe getting a partial revocation order, doing a bit of a financing and raising the money for the audit, and then they file the financial statements. We will go back, we will look at the compliance record, and we will look at things like failure to file material change reports as a conduct issue. So just one thing to keep in mind if you're in that failure to file situation. Is there an alternative to a cease trade order if you're sort of in that weeks or month before you're about to your filing deadline is coming up, there's nothing you can do about it? In the scenarios that we're talking about with companies in financial distress, the practical answer is really no. In other circumstances where you have an inability to file, say it's access to records, you've just done an acquisition of a foreign entity and you're having problems getting some of the records, there is an alternative that we call a management cease trade order. So when we issue a cease trade order, as I'm sure everybody knows, no trading can take place on the stock exchange anywhere in the jurisdiction. No IROC dealer will touch any transaction, whether it's domestic or foreign, related to those securities. When we issue a management cease trade order, all we name is the CEO and the CFO, prohibit them from trading. They're probably prevented from trading anyway anytime there's undisclosed material information such as financial statements. So that is an alternative in certain circumstances. It's not really a practical alternative in the case of running out of money, because one of the criteria for us issuing a management cease trade order is that the company has to have the resources to be able to remedy the deficiency, and it has to be able to do so in a fairly short period of time, 2 weeks to maybe 2 months at the outside. So chances are, company is out of money. That's not something it's going to be able to do, but at least keep that in mind. So what happens when you are cease traded? How do you resolve the cease trade order? So assuming the company is able to resolve the financial issue, and now it's figuring out, okay, well, we can get our audit done, we can file our financial statements, what else do we have to do? The key date is 90 days. If the cease trade order has been in effect for less than 90 days, in British Columbia, simply file the financial statements. That's all you need to do. We will look at the financial statements. As long as they're in good form, meet all the requirements, we will revoke the cease trade order, and we'll do it within 2 business days of receiving a filing in good form. If it's more than 90 days, then you're into more of a detailed review. Our securities regulation provides a clear distinction between the before and after 90 days. Once you're into after 90 days, we're going to take a detailed look at the management, their past conduct, their compliance record, the disclosure record. And this is where we're really going to look at things like having filed material change reports when necessary and things like that. There's also an application required. A fee is required. So under 90 days, just file the financial statements and you should be good within 2 days. More than 90 days, it's a little bit more complicated. Another question I was asked in preparation for this is, can a company die in the corporate legislation side as a result of something that it's done or failed to do on the securities legislation side? There's probably people in here who know more about this than I do. As far as I know, the answer is no. So corporate law determines whether a corporate exists, whether a corporation exists, what has to happen for it to be dissolved or wound up or to cease to exist in some manner. Securities law is about disclosure, it's about securities trading. Nothing you do or fail to do on this side will directly result in a company somehow ceasing to exist on the corporate side. And so before I move on, I just want to just really clarify as a securities regulator what our philosophy is around the cease trade order and the defaulting issuers list. We often get people call us up when we're putting them on the default list or just after, when we're about to issue a cease trade order, and they say, why are you doing this? We're a good company. We've done all these good things. We've employed these people, and we're just running into some bad luck. And why would you do this to us? It's hurting the company. It's hurting the shareholders. And all that may be true, but that's not the point. Our system of securities markets and securities regulation depends on disclosure of information. And baked into the rules are deadlines that essentially say the information is up to date until these deadlines. And if you haven't updated that information by those deadlines, then that information is really too old for investors to be able to make informed investment decisions. So it's not that we're trying to harm the company. It's not that we're trying to be punitive, because we're not. Our focus is entirely, in that case, investor protection. We need to be able to prevent investors from trading in those securities. And some people will say, well, can't we have more of a caveat emptor model? You know, you put out a notice, these guys never filed their financial statements, buyer beware. Do what you want. And you know, while there's, you know, sort of philosophically nothing necessarily wrong with that, that's not the model we have. And if we allowed that to happen, you know, people would trade. If somebody would lose some money, then they'd say, hey, where were the regulators to protect us? So currently that's the situation. So that's the doom and gloom portion. I'm going to move on to the ray of sunshine part. But before I do, I just wanted to mention for the people sort of sitting in the main part of the room, you'll notice you've received 2 continuous professional development credits for attending this course, as evidenced by that certificate. Now, if you'd sat in one of the front rows, you could have, I think, as much as 16 CPD hours. People standing in the back, you get nothing, so too bad. So the securities regulators, including BC and our CSA colleagues throughout the rest of the country, have recognized that the compliance burden on venture issuers could be viewed fairly as being disproportionate to the size and resources of the venture issuers. So we set out to try and do something, right? We set out to try and do something about this over a period from May 2010 to about this time last year. And it was a series of consultations where we proposed a separate regulatory regime for venture issuers, and some of you may have participated in that process, either face-to-face meetings with us as regulators or reviewing our publications and submitting comments. Our goal was to streamline and improve the governance and disclosure regime. We wanted to eliminate unnecessary burdens without taking away any of the key disclosures that we know that venture issuer investors use when they make investment decisions. So there were 2 key elements of that proposal. One was a single annual disclosure document. It was sometimes compared to an AIF, and I think that's maybe a little unfair, and that was one of the criticisms of it, was too onerous for venture issuers. The idea was that it was going to be a collection of all the annual disclosure that a company typically makes anyway, MD&A information, some information out of the information circular, and a little bit of background information about the company. The second element, and this was the one that was probably on the marquee, was the proposal to eliminate quarterly financial reporting. So right now, companies have to file first, second, and third quarter, as well as their annuals. We were proposing to eliminate the first and third quarter disclosure requirements, really moving to a semi-annual financial disclosure system. So eliminate the financial statements, eliminate the MD&A, and eliminate the certificates in the first and third quarter. When we published, we got positive reaction to the concept of the regulatory regime. We received 70 comments on the 2011 version of the proposal. Half of those comments were from issuers. The vast majority of those were venture issuers, and the other half were from a wide array of institutions, lobby groups, professional advisors, so all sorts of different people were the other half. So really the bulk and the main group commenting to us was the reporting issuers, the public companies. And what they told us was they supported the concept, but they didn't support the idea of eliminating first and third quarter reporting. And we found that really interesting, and it wasn't what we expected, which is, you know, probably says, hey, it's a good thing that we're going out consulting instead of just thinking we know what people think. So, and the reason explained to us was that companies are always trying to attract investors. They're competing with American companies in particular, or trying to attract American investors, where the standard is quarterly reporting. Even though semi-annual reporting is a standard in pretty much the rest of the world, here it's quarterly reporting. And a system of semi-annual reporting, no matter how robust and no matter what other elements in there, no matter what other corporate governance items we might add, would be seen as a less than standard than the standard of quarterly reporting. And in fact, the companies told us that even if they themselves still filed voluntarily quarterly financial statements, to make up that gap, it still wouldn't be enough because the system didn't require it, and therefore it wouldn't be seen as reliable or as robust. So we took that and said, okay, well, we certainly don't want to force that down the companies if that's what they're telling us. So we republished in September of last year, and we put back in the quarterly reporting, but we took out the requirement for management's discussion analysis because we thought, okay, well, at least there's something that we think we can do about this, and I'll get to what that proposal was in a second. So interestingly, the second time around, the volume of comments went down from about 70 to 20. The overall tone of the comments was far more on the negative side, and the consensus view was more, the idea is a good one, but now is not the time. It's a bad time in the market. We've just had this IFRS thing, International Financial Reporting Standards, and we just, if we have a 700-page rule book that we know and understand, it doesn't help us to give us a 350-page rule book that we don't understand, even if we think it's better. It may be good to do this at some time, but now is not the time. So in July of this year, after really reviewing, assessing, and considering those comments, the CSA, including the BC Securities Commission, announced we were not proceeding with this venture regulatory concept. The feedback was just too clear that the support for the benefits wasn't sufficient to offset the costs to the market participants. So we're still considering elements from this proposal because we think, okay, it's the regime that's the problem, the challenge to the companies. It's the burden of having to understand an entire regime. But are there items that we can select that would work to improve the system, maybe do some streamlining, and maybe make it a little bit more proportionate for venture issuers? So we're still not convinced that quarterly MD&A for venture issuers is particularly useful for the investors. If you go to our website and you print out the instructions for MD&A, it's 21 pages long. So you need, and there's people going, yeah, duh. You need to plow through 21 pages of instructions to tell you how to tell your shareholders and potential investors what was important that happened in the last quarter. And we think, well, first of all, 21 pages of instructions might lead to a dozen pages of sort of boilerplate, repeat numbers from the financial statements, et cetera. And there might be a page or two, or maybe a page of actual key information. And we think, well, maybe we can go out and we can provide instructions in 2 or 3 paragraphs that say, describe what was important to your company in the last quarter. Focus on events, milestones, results, financial situation, cash flow, working capital. And if we can describe that in 2 or 3 paragraphs, and companies can maybe put that together in a page, we think that's probably viable for some or all venture issuers. There's other elements too. Business acquisition reporting we heard about can be complex and difficult. There might be room to streamline that. Executive compensation disclosure, there's probably some areas there where the one-size-fits-all regime that we have may not be necessary for venture issuers. So we, as a regulator, we appreciate that a few changes to the disclosure regime will not solve the problems related to the market downturn. As a regulator, our role is to balance the sometimes competing goals of protecting investors and fostering efficient access to capital. We can't simply throw away the rule book when markets are depressed, but we can take a good hard look at the rules we have and find ways to improve the efficiency for the benefit of all securities market participants. So stand by. We should have something out relatively soon that should do something. So leave it at that, I think, for now.